Welcome back to Law and Crime. I'm Misty Marris. We're here waiting for the Bob Ward case to take off in the courtroom. We know that the judge is on the bench giving some jury instructions, and we anticipate that the opening statements will take place soon. While we wait to go live into the courtroom, we're here with Vinoo Varghese. He's breaking it down for us about how we see this case unfolding. Now, we know that the prosecution is going to get up there and make their opening statements. This is a retrial because conviction was overturned on appeal, but there was a conviction at some point. So is advantage in the prosecution's camp?
That's a tough call to say. I would say, look, I've had a couple instances in my own career where there was a mistrial, and on the retrial, we won both times, twice in my career. And it was the advantage of having to look at this, and in the first mistrial, I was able to actually speak to the jurors. The judge did a great thing in there, and the prosecutor and I went to the back and found out exactly how they split. And I thought that was an amazing thing, because from that lesson, I knew what the issue was that was holding that up. And on the retrial, I was able to exploit that issue and hammer down it and to make sure that that issue didn't come up. So I would like to think there are advantages in the defense side. That's the way I'd like to think about it, but you don't know.
Well, I suppose on both sides, prosecution and defense, you get the opportunity to look back. You're looking back at the full record, and you're finding those weaknesses, and you have the chance now to plug them up. You have the chance to, are there any other witnesses? Is there anything else that could potentially be helpful? Is there a way that you can spin this, or something you can say in your opening statement or closing argument that might help sway the jury? Certainly, and I suppose on both sides, there are advantages and disadvantages. Because you know what? You've shown your hand. Sometimes the element of surprise is really important in a trial, but you lose that a little bit the second time around.
You know, it depends on how much surprise there was. I mean, at this point, and hopefully, you know, long before trial, you know, the discovery was out there, they were able to review anything. Hopefully there were no surprises at trial. And the issue is, how are they going to argue, right? So, you know, for example, in this retrial that I did, and it was a attempted murder case a bunch of years ago in Brooklyn. The prosecutor opened up, and it had to do with an employee of a construction company who was charged with attacking his boss with a knife, and they said he did it over money, right? And so he opened up in the first trial, and he said, you know, money causes people to do desperate things, and people do anything for money, and that's why he sliced up his boss. That prosecutor, the same prosecutor, opened up the second trial, and he said the same thing. And so when I got up and I did my opening, I said, yeah, in these financially hard times, why would the state bring this ridiculous case, right? So I couldn't believe he reopened on the same thing. So the question is, will these prosecutors learn and do something? I don't know. I mean, a lot of these guys, they believe that what they're doing is, you know, is God's work, and that they don't want to hear criticism. They don't want to think that, you know, this is a problem that a lot of prosecutors have. They don't believe that they do anything wrong. So will they listen? Will they reevaluate? I don't know.
Yeah, sometimes it can be hard to look at it objectively, right? Which goes to your point. Sometimes a fresh set of eyes walking into a new trial can be really helpful. That being said, in this particular case, it's not a retrial because there was a mistrial. We had a conviction that was overturned. So the question is, and a lot of the viewers asked this question, what, if anything, is going to come in from the last trial to the new trial? Can the prosecution make the point that he was convicted before?
No.
That's wiped away.
No.
So what is at stake here? What are we going to see as a repeat?
I mean, I think they have to present the evidence, but they have to do it in a way that doesn't cause, without reference to the previous trial. So I've done 2 trials or 2 retrials, and in both of those cases, you referred to it as a prior proceeding. So it would be curious to see how the judge deals with it, because potentially there's going to be testimony that comes up, and if the defense or the prosecution wants to impeach, let's say there's a prosecution witness that testified, you know, at the second trial, but he testifies in a way that was contradictory to the first trial, the defense will have the opportunity, because they'll have the transcript, to go, okay, in a prior proceeding, while you were sworn, on this date, you gave this testimony, correct? And this was a question you were asked, and this was the question how you answered it, right? That's impeachment. That's confronting a witness with a prior inconsistent statement. So that's, to me, that's in the defense's advantage. You know, is that they'll have this, and hopefully, I don't know, this is where there's the institutional differences, right? So, you know, you have the prosecution. A lot of times these guys are shedding their ways, and hopefully these lawyers, and this new lawyer, you know, will look at the mistakes and not repeat the mistakes of the previous lawyer.
Yeah, I'm certain that you'll see the defense really going crazy on making sure their objections are on the record. Obviously, that's really important. Although...
To an extent, because as a defense lawyer, you run the risk, if you're consistently objecting, as seeing to be sort of an obstructionist.
Right.
Being afraid of the evidence, right? So that's a really tough call. I mean, I've had situations where certain things I know are legally impermissible and I have to make a cost-benefit analysis. Is this something that's really terrible that I need to object to, or can I let it go because I don't want to seem like the guy who's jumping up and down all the time, because I'm afraid of the evidence. So that's the dilemma of the defense lawyer.
Right. It's a balance test, because on one hand, you have to make sure that you're getting all of your valid objections on the record. Although, hey, in this particular case, it actually inured to the benefit of the defendant,
right,
that he ended up with a new trial. But that is, to me, a bit of a glaring mistake with respect to what was done in the first trial here, that the defense failed to put those objections on the record based on his lack of information that he provided. I mean, you don't have to say a darn thing if you don't want to.
Sure, but it actually speaks, I think, just as badly for the prosecution that they went that route.
25 times.
Right.
And let's not forget, it wasn't one time, it was multiple times. If it had been once, who knows? The appeal might have come out differently.
Right.
It might have not had such an impact.
Correct. I think this isn't the kind of case. So on appeal, a court will they'll look at something with a harmless error analysis where, okay, it was error, it was legal error, but the evidence was so overwhelming that you can let it go. I'm not sure in this case they can apply the harmless error standard in an appellate court, because the facts are ambiguous, right?
Right.
I mean, you know, you don't know. I mean, no one else, there are no other witnesses. He called the police. There seemed to be no attempt to cover this up. So anything that the prosecution does is actually magnified. And particularly, you have to ask why the prosecutors went that route. It's a terrible way to go, because you are commenting on a defendant's right to remain silent.
Right.
You shouldn't do that as a prosecutor. It's fundamental constitutional violation. That's why it was overturned.
Absolutely, and that's why we find ourselves back in this Florida courtroom today. We're going to go live where the Bob Ward opening statements are taking place.